1498887-001. We do have one witness. It's Hugo Lopez, correct?
Yes, Judge.
Hugo Lopez is the witness who will be testifying after the current witness. Mr. Lopez's testimony is not to be live streamed. There is to be no audio or video depiction of Mr. Lopez's testimony. And if you would like to come back and take the witness stand, we will bring in the jury. Thank you. Ms. Dahl, did you want to proceed with the playing of the video, correct?
Yes, Judge. Thank you.
You're welcome. You may.
Before we begin, Ms. Griffey, we only see 3 cameras here. Could you explain why another image may come on shortly?
So what we found when we were processing the DVR is that the cameras were set to motion activation. So you'll see some cameras kick on and kick off as the motion activation is triggered. Sometimes it's triggered by like flies going through the camera view. Sometimes people are sitting still long enough that the camera will go to sleep, and then they'll turn slightly and the camera will kick back on. So we may see some of those things happening as we watch the video.
Thank you. Was this important to the investigation, the image that I just stopped at 9:39:43?
The subject was described to us when we were reviewing the video as a Hispanic male that arrives on a bicycle. So that was one of the things that we were looking for. The subject was described as a Hispanic male that arrives on a bicycle but does not leave on the bicycle. So when we reviewed this video and we found this person coming in on a bicycle and leaving without the bicycle, that was a point where we contacted Detective Butcher to make sure that this was the person that she was looking for.
What was significant about that point at 9:40:41 on the video?
At that point, the subject that was pointed out to us was handed a telephone from one of the people at the, I'm sorry, I apologize. At that point, the subject was handed a telephone by one of the people at the internet cafe.
Did he appear to have a small goatee in that image?
Yes, he appeared to have some facial hair.
At that point, was the phone handed back?
Yes. Yes, it was.
Ms. Griffey, what direction is the subject walking now?
They're headed north right now out of the internet cafe, and then they're going to head west down Buckeye Road.
Your Honor, I have no further questions at this time.
All right, it appears there's at least one juror question. Are you okay?
Yes, ma'am.
Okay. You need a break, or are you good?
I'm okay.
Okay. Taking into account the time difference on the video timestamp, how long after the shooting did the subject arrive at the business in the video?
Excuse me. I believe it was within 45 minutes. I'm so sorry.
Okay. You all right?
Yes, ma'am.
Okay. Any follow-up, Ms. Dahl?
I'm going to put exhibit 276 on the Elmo. If the shooting occurred around the time of 3:06 a.m. and the individual is first seen arriving at 9:39 and the video was actually captured 5 hours and 47 minutes earlier, would that be between the time of 3 and 4? Not forcing you to do the math in the stand, but
Thank you, I appreciate that. Yes, it is between the hours of 3 a.m. and 4 a.m.
so 9:39 minus 5 hours and 47 minutes.
Yes, ma'am.
Nothing further.
Thank you.
Nothing
Other
from me,
rounds?
Judge. Thank you.
One more juror question. One last question. Were there any others who came to the cafe matching the description you were given to look for?
We saw a lot of individuals coming with bicycles to the internet cafe, but we didn't see anybody leaving without the bicycle that they had arrived on. In this instance, he left with a person on the bicycle that he had arrived with, but he wasn't on the bicycle, and that was what Detective Butcher had been told, and that was what she was looking for.
Thank you. Any follow-up?
So there was a specific description that Detective Butcher provided? Is that yes? Yes. There was a specific description of the individual that may have met with the defendant, correct?
Yes.
And there was a very specific time frame, although you looked from 3 a.m. to 5 p.m., correct?
Yes.
Were you really targeting the time between 3 a.m. and 4 a.m.?
I'm so sorry. She had been given a time frame.
And did you follow up on that time frame?
Yes.
Nothing further.
I have no questions.
All right. That does conclude your testimony. Thank you very much for coming in. You are excused, and that is okay.
Thank you. Thank you for the order.
Would the state like to call its next witness?
Yes, the state calls Hugo Lopez, Judge.
Mr. Champion, if you could please come forward and be sworn in by the clerk.
Hello. Can you please state and spell your first and your last name?
Yes, it's Joshua, Joshua, Champion, Champion.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Whenever you're ready.
Thank you, Your Honor. Could you please introduce yourself to the members of the jury?
Yes, I'm Special Agent Joshua Champion.
Special agent sounds different than what we've heard in this case. What does that mean?
I've been employed since September with the Arizona Department of Insurance, and that's the title for detective there.
Okay, so let's talk about your time when you were a detective. Could you share with us your experience with the Phoenix Police Department, Special Agent?
Yes, I started back in 1997 as a patrol officer. I worked approximately 7 years on the northeast part of the city. In 2004, I tested for and was accepted into the robbery unit of the Violent Crimes Bureau. I stayed there for just over 3.5 years when I tested for and was accepted into the Violent Crime Bureau's homicide unit. Approximately 2013, I went from what's called a response squad in homicide to the resource squad. I believe it was in 2015. I did almost a year in our special investigations unit, which is where we investigate city employees, including officers, firefighters, for criminal offenses, not just for policy violations. I returned to homicide for about 3 months when I tested for and was accepted into the vehicular homicide unit, formerly the vehicular crimes unit. And then I retired in December of 2018 with 21.5 years.
Do you have specialized training and experience as it relates to cell phone extractions and that type of forensic examinations of devices?
Yes, I do.
Tell us about that, sir.
When I went to the robbery unit in 2004, I started on-the-job training on interpreting, to obtain through legal means, court orders, search warrants, records from cell phone companies, and then interpreting what the information was, such as which towers were being used, different phone numbers, the equipment, the technology for cell phones. From 2004 through 2013, I've had, and this is going to be on the conservative side, over 500 hours related to two different types of cell phone analysis. One is related to records, and the others to extracting data from devices.
Has there been significant changes in technology as you saw it in that area? For example, from 2014 to 2019?
Yes. Even from when I started in 2004, the first smartphone, the first Apple did not come out until 2007. And then smartphones were not in common use for another 3 to 4 years. And then even from 2014, if you had a 4 gigabyte phone, that was huge. Now 2019, you could have several hundred gigabytes on a phone and not be uncommon.
What was you said you were on the resource squad with the homicide unit in 2014, which would encompass obviously October of 2014, correct?
Yes.
Tell us what it meant to be on the resource squad at the Phoenix Police Department's homicide.
When you go to homicide, you go to what's called a response squad. There are 4 squads. Each squad is responsible for a particular day. So come Monday, let's say the 31 squad is responsible for all homicides that occur in a 24-hour period. Then on Tuesday, the 32 squad is responsible for, and 33 and 34. And it just rotates. So it's not necessarily that you have every Monday that you're going to be responsible for any homicides that occur. It rotates, but it's every 4 days. The resource squad was created because there were some investigations that took extensive time, needed more resources. Sometimes out-of-state agencies would come into Arizona and you would assist them. And resource or response detectives didn't necessarily have that time. The reason why I was selected for that was for my cell phone training. So I was put into a specialty position in the homicide unit. That position eventually changed into what is now the digital forensic investigative unit that does cell phone and some computer extractions.
How did you first become involved with the investigation involving the defendant in this case arising out of the events on October 8th, 2014?
I got notified that there was an officer-involved shooting where an officer was shot. So I immediately asked what needed to be done. One of the things they asked as a resource squad, because we didn't know the condition, Officer Casey, was to respond to the hospital, determine if it was going to be a survivable injury or if it was going to be fatal, the extent of the injuries, what type of medical treatment was going to be needed and when he may need or may be able to be contacted or interviewed, reference this, and to collect any medical and physical evidence I could.
And that was the evening of the shooting, correct?
Yes.
What were you able to impound, for lack of a better word, or collect from the hospital?
At the hospital, I collected 3 items that came from the hospital. The first 2 I did collect at the hospital. One was bullet fragments that I received from the patrol officer that was on scene at the hospital initially.
Tell us about that process.
I went into I believe that one was in the CAT scan room. So he was undergoing a scan to see what injuries there were to the head, neck area, so that they could make sure that they were giving all medical treatment that was necessary and they weren't missing anything. When I arrived there was a patrol officer in the room where the technician was at, and that's where I went into. I contacted the officer to see what the doctors and nurses had been telling him. And at this time, he told me that he had some fragments that were provided to him by the doctors on the initial surgery. So I took custody of that.
You say fragments, you're talking about bullet fragments.
Yes.
So you took custody of that and you impounded it?
Yes, I did.
Was there something else that you impounded?
Yes. After we left that room, we went back to the operating room. At that point, I met with a nurse, and she provided me with a container that had teeth and a portion of Officer Casey's jaw.
What else did you collect?
Then when I returned back to our headquarters at 620 West Washington, Officer McLaughlin, who was the officer that gave me the initial bullet fragments, he had remained at the hospital a little longer, and they were able to extract more bullet fragments. So he transported that to me and handed that over to me as well, and I impounded that.
Were you part of the process of getting search warrants in this case?
Yes, I was.
what role did you play in obtaining search warrants, some of the search warrants in this case?
Because I was on the resource squad, I basically did not have a set role. I didn't need to do, I could do anything that they needed as investigative support. Some of the things that I did was I wrote a search warrant for the vehicle once it was located that was involved in the shooting. I wrote court orders for cell phones, or search warrants for cell phones. I wrote court orders to obtain identifying evidence from different individuals.
Well, let's talk about what that is. What does a court order to obtain identifying evidence from different individuals mean, at least in this case?
Court order to obtain identifying evidence is where I petition the court and ask to obtain specific evidence from specific people. What we need is to have reasonable cause to explain why we need this evidence. The things that I was looking for is I knew there was 3 individuals that were identified as being in the car at the time of the shooting through the investigation. So this was not written on the initial day. But from that, I asked for palm prints, hand prints, buccal swabs, and blood samples. We could use those either as elimination or confirmation to any evidence obtained from the scene.
Could it be exclusion or identification?
Yes.
Did you extract data from Louis Perez's phones?
Yes, I did.
And what is the process of extracting data from phones that have been impounded?
There are 4 different types of searches that can be done. I'll go from the most basic up to the more technical. 4 types of primary searches that we do at Phoenix PD. There are multiple other searches that can be done, but I didn't have the technology. The first one is what we call a manual search. That's where you pick up the phone, power it on, and you start looking through, checking contacts, checking text messages, physically looking at this. As police officers, we do a manual search. We'll have a screen, we'll take a picture of it with a camera, move it to the next contact, take a picture of all that information. The drawback to this is you can only get the information that you can see. So if the phone is locked, you won't be able to see much other than a header screen. The other thing is if you're in the call logs or in the phone book, if you mispress or touch something wrong, you have now just dialed a number, added data to a list that may, depending on the type of phone, delete older information. The tool that we use most frequently in the Digital Forensic Investigative Unit at that time was a tool called a Cellbrite. What this tool was originally used for is when we had flip phones back in the day and I got a new phone, so I didn't have to manually re-enter my phone contacts. The phone companies actually had it where they would plug it into a Cellbrite machine. It would extract your phone call list, your contact list, and then put it into the new phone for you. At some point, somebody realized this would be a great tool, and Cellbrite started making what they now called it the Universal Forensic Examination Device, or UFED, UFED. Over the years, Cellbrite has been a very good tool for the fact that it can get some data almost for a majority of phones. Whereas some tools may only be able to get data from smartphones only, not flip phones or what we call dumb phones. But it can't necessarily get everything off of that phone. So it's a universal tool where it may get some data off of everything. So on a Cellbrite, there's 3 types of searches. There's a logical, which where I plug it in, I'm not touching it, where I can do any manipulation of data, and that will electronically and forensically get data that is similar to what you would find in a manual search. If you can see it on the phone, it should be able to pick that up. I liken it to if you go into an office and you see papers on a desk, you would be able to see the papers on the desk and you wouldn't have to move it around with your hands. It would copy all that information. The next type of search is a file search. It's a little more intense, that tries to look at the phone as a computer system going through the individual files. What I liken this to is not only do you go into an office, look at the papers on the desk, but now you look through file by file in a file cabinet. So you may get more data than you do from a logical search, But depending on how the phone is, it may just be duplicate data, but you may get some more data from there. And the third one is called a physical search. This is one where it goes in and tries to read the information, all the information from the phone. And sometimes you can pick up deleted data because the way computers and phones process information, they don't necessarily delete or erase something. It'll just change a digit indicating to that phone system or computer system that that space can now be written over. So it is possible you can get deleted data. Using the office example, not only do you get the information off the desk and from the file system, it would be like going through the shredder bin and trying to put some stuff back together. You may still have a large pile that you can't put together, you can't do anything with, but every now and then you may be able to get some deleted data.
In this case, did you obtain and search the phone received from Valeria Jaime's mother?
Yes, it did.
Did you obtain and search the phone of a man by the name of Daryl Claiborne?
Yes.
And we talked about the fact that you did it with Louis Perez's phones
Yes.
and Valeria Jaime's phones. Did you do the same thing?
Yes, it did.
Now, there was a search done of the phone that was found with Ramon Bueno when he was arrested, correct?
Yes.
Was there very much information that could be derived from that phone?
No, on that one, as I said, Cellbrite can get some data from a large variety of phones, but there are some phones that it just cannot. And this one, the Cellbrite did not support. And so this is one where I had to do that manual search, physically look through, take pictures, switch a screen, take pictures.
And you did that in this case?
Yes.
Now, you also did a big interview in this case, right?
Yes.
Was that the individual by the name of Pete Conyers?
Yes.
And was Pete Conyers one of the individuals that was found in the house with the defendant on October 15th of 2014?
Yes, I believe Mr. Cañas came out of the house before Mr. Bueno was located.
And in this case, all of that data from these phones, was this a case where the cell phones were deemed to be really important or helpful to the investigation?
Yes, initially on the first several phones that we were doing, we were trying to find contacts, known associates, locations that we may be able to use to try to locate where Mr. Bueno and Ms. Jaime may be. Then after that, once they were in custody, we copied or extracted data, either photos or through the Cellbrite, and I provided that information to the case agents.
And was information regarding contacts between individuals and contacts within the phone, was that important?
Yes, it was.
And was some of the data derived from Ida Bueno's computer regarding a telephone number, was that important?
I did not do any of the computer analysis on that, on this case.
I have nothing further.
Mr. Lorenz?
No questions, Judge. Thank you.
Do any of the jurors have questions? Seeing none, that does conclude your testimony, sir. You are excused. Thank you for coming in.
Thank you, Your Honor.
Ms. Dahl?
Judge, I didn't think we'd go this fast today with these witnesses. I have no further witnesses at this time.
All right. We are going to break early for the day. We will be back on the record tomorrow morning at 10:30. Please remember the admonition applies. You are not to discuss the case among yourselves or with third parties. We'll see you tomorrow.
All right, adjourned.
All right. Tomorrow look like.
Larry Martinez from the railroad, Tom Bertoni, who is a crime scene specialist, Zuckerbrow, who is a DNA analyst. I need to put my list. James Casey, And I'm trying to think right now, I'm at a little bit of a loss. I'm trying to pull up my list.
I had civilians 1 and 2 for the trains. Is there only 1 for the trains?
Yes, right now, there's only one.
Okay. And Mr. Casey will be your last witness, correct?
Yes,
It's possible we could begin his testimony tomorrow and continue over into Monday, is that right?
yes.
Okay. Is there anything you all wanted to address before I turn to questions on the jury instructions?
No, Judge.
No, Judge?
On the final jury instructions, the state has requested some definitions, and some of them were duplicative, and I just wanted to know if there was preference for the wording in one over another, and I'll tell you what I'm referring to. When we look at the jury instructions, you requested, and this is in the filing that I received on December 10th, there's a statutory definition at 1.0515 for deadly weapon. There's also a definition in 31.01 for deadly weapon. They are almost identical, but not quite. If you would like, I can read the two to you and you can tell me which version you want. Do you want me to do that?
Sure, Judge. I think the version that says a firearm is a deadly weapon is the one I would prefer. I'm pulling up mine right now. I apologize.
That's okay. For Mr. Lorenz's benefit as well, I'll just read it all.
Thank you, Judge.
So, definition, the first one, deadly weapon means anything designed for lethal use, including a firearm. Or the second one, deadly weapon means anything that is designed for lethal use, period. The term includes a firearm. You want the second definition?
Yes.
Any objection?
No objection.
Okay, I'll strike the first definition. The second issue was officer or public officer and peace officer. In your requested instructions, you requested 1.0529. That defines peace officer. Then on the next page, you requested 38.101. That is an officer. I don't know that we want that definition of officer. I'm going to read it to you. First, peace officer means any person vested by law with a duty to maintain public order and make arrests. That seems to apply. The second, officer or public officer, means the incumbent of any office, member of any board or commission, or the deputy or assistant exercising the powers and duties of the officer, other than clerks or mere employees of the officer.
You are right.
Okay.
I agree.
I'm going to strike the definition of officer or public officer from what you requested. The next question I had was on attempt to commit first-degree murder. What I am going to do is I'm going to include the definition of attempt from the directions. Then I'm going to include the definition of first-degree premeditated murder. That is the instruction you want, correct? Not, because,
Judge, I looked at the indictment. I couldn't do the one with the officer because it wasn't charged that way.
right, okay, just wanted to make sure. So we're including the definition of first-degree murder premeditated.
Yes.
Okay. And then within the definition of premeditation, there is a parenthetical at the end of that definition, which reads as follows. I'll start with the beginning. So premeditation means that the defendant intended to kill another human being or knew he would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion, period. The parenthetical is, the time needed for reflection is not necessarily prolonged and the space of time between the intent or knowledge to kill and the act of killing may be very short. Did the state want the parenthetical included?
Yes.
Does the defense object to including the parenthetical?
The defense does not object.
Okay, the parenthetical will be included. We do not have any witnesses with priors that were used to impeach them, correct? Ms. Richardson only testified to having used methamphetamine, not to having a conviction, correct?
Judge, she was convicted in this case, so that's why I think it does apply.
That's true.
So that was not requested. Let me add it back in. Okay. Mr. Lorenz, I believe this will go to you. Instruction 18A is that the defendant need not testify. The standard instruction has a parenthetical. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant acting with the advice of an attorney. You must not let this choice affect your deliberations in any way, period. Parenthetical. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. Assuming hypothetically your client does not testify, do you want the parenthetical included?
Please.
Any objection? Okay, parenthetical will be included. Dangerous offense. Dangerous offense includes various parentheticals. I need you to tell me if you want one or both. Dangerous offense means an offense that involved, parenthetical, the discharge or use or threatening exhibition of a deadly weapon or dangerous instrument,
Yes.
the intentional or knowing infliction of serious physical injury on another person.
No, Judge, that wasn't in the indictment.
So dangerous offense will be limited to the parenthetical I just read into the record. The only states of, we're only including intentionally or with intent to, or knowingly. We are not including recklessly, correct?
Correct.
All right. And if we get a guilty verdict, I assume there will be an aggravation phase?
Yes.
Can you tell me at this point which aggravators you would be seeking?
Judge, it'll be, I can tell you at a minimum what they are. I can definitely come back in tomorrow morning. It'll be the harm to the victims,
Okay.
the criminal history, the prior felony convictions. Those are the two main ones. I can look and see what was filed.
So the priors would be determined in a priors trial by the court, correct?
Right, but I could also prove them to the jury.
Okay.
I haven't encountered that since we don't try them to the jury anymore. I'd have to ponder that.
Yeah, I have to ponder that too. I thought there was a rule change that it has to be tried to the court.
I don't believe so, Judge. I haven't encountered this recently. Obviously, we prove priors in capital cases to the jury all the time, serious events and so on. I think it's something that can be proven to the court, but can also be proven to the jury. Just like on probation, there's some things that must be proven to a jury, but can also be proven to the court.
Okay?
I don't have that in front of me.
I don't either.
I didn't anticipate that.
Judge, we used to try, the trial on the priors used to always be to the jury, and I think that's changed, but
But in this case, I'm not proving, so the defendant has more than 2 historical prior felony convictions. It's not just for sentencing purposes to move him into the category 3. It's to prove up the aggravating factor. I don't see why we couldn't do an aggravation, prove it to the jury, which is convincing the jury of yet another aggravating factor, and having that verdict.
Give me just a second.
I have to look at the others that were alleged in this case. There's also, Judge, the gang sentencing enhancement, which needs to be proved to the jury. And I would recall Clint Davis for that.
In the aggravation phase,
Yes.
5 years, right?
Pardon me?
It's 5 years?
Yes.
If I didn't have time, I wouldn't make you sit there, but we do have time, so I'm going to do this right now.
thank you, Judge.
Statute. Oh, that's the wrong one. Where's it? 'Prior,
Prior serious?
yeah.
Yes. He does here. I can pull up all these allegations. I'm just having trouble connecting to the internet.
$13,701. Oh, I just had it and then I clicked on the. Yeah, subsection D, 13701D provides that the court shall determine an aggravating circumstance under paragraph 11 of this subsection. Paragraph 11 is the defendant was previously convicted of a felony within 10 years immediately preceding the date of the offense. A conviction outside of the jurisdiction, and you know the language. Is there something, Ms. Dahl, that would take the aggravation that you're intending to prove with the priors in this case outside of that language?
Judge, I don't know if that's in the context of 701 to do it for sentencing enhancement in terms of the categories. I just find it easier to do, instead of, be easier just to show the pen pack to the jury, have them make the finding. I can do it to the court too. I can withdraw it, but.
Well, I'm just focused
I
on the
just
word
like to get all
shall.
that.
I know. I'm focused on the word of the statute, which says shall. So is there a reason that I wouldn't have to follow the language in the statute that says the court shall determine an aggravating circumstance under paragraph 11?
No, Judge, I can do that here.
Okay. So we will not include prior felony convictions as an aggravating factor in the aggravation phase, if we get there, that will have to be done in a priors trial to the court, subject to any stipulations the parties may reach. All right, so you'll come prepared tomorrow to tell me what other aggravating factors you might want to see or
Yes, Judge.
prove? Okay. Then I will get you these jury instructions tonight. We will be prepared tomorrow to discuss them and any changes you might want me to make.
Yes, Your Honor.
We'll have those finalized by the end of the day tomorrow, of course, subject to the language where we will determine whether or not the defendant is testifying or not.
Thank you.
Is there anything else we can address?
No, thank you very much.
All right, thank you, everyone. Have a good evening.
Night.